Okay. Can medical providers speak with non-guardian parents? Can the parents provide informed consent? They absolutely can. Take a look at RCW 770065. That is the informed consent law. And it basically says if you have a disabled individual, here are the people who can make decisions. And I screw up who the first priority. I think first priority is guardian and power of attorney too, or maybe vice versa. And then below that, you've got parents and children, and there's this whole list. So in theory, we shouldn't need a guardianship for certain medical decisions, but often we are forced to do that. Where you see this dichotomy sometimes is I don't run into a huge amount of problems in the long-term marriage situation. Usually, if one party is incapacitated, the other one usually can make those decisions. Money is sometimes a little bit difficult. But if it is a child acting on behalf of their parent, there is often going to be problems because the medical people are going to say, who are you? What's going on? HIPAA, we can't talk to you. So that's often where we sometimes end up in those situations. As I said, a basic power of attorney is a great alternative, and we'll do that as I yammer on and on. I also think there's a common law that parents are able to make decisions for their disabled children, and I think that is the case. I think it's happened. I'm really amazed when it comes to kind of my youngins how varied the things are, because I have had Seattle Children's Hospital says once somebody turns 18, HIPAA applies, and therefore we can't talk to anybody about anything. But I've also seen situations where other doctors understand. I have a 21-year-old stepdaughter with autism, and I know her mom has been, much to my chagrin, operating without a power of attorney and having no problem. And I have a lot of people who have no problem. I think that's because everybody's kind of tracking, and our child is pretty, unless you're going to give her a shot, and even she's gotten better about that, she's pretty easy to get along with, except back when she was 12 and trashing doctors' rooms every time she had to get a poke. All right, one of the things, again, on the youngins is sometimes IEPs are an issue. One of the things that I need to be better about, and I highly recommend to everybody, is if you are doing a power of attorney, put IEP language in it. I don't have that standard in my power of attorney, but I absolutely put it in when I have a minor turning 18 who might be still in school. And remember, the kids can stay in the transition programs until they're 22 now. So you may have a period of time. There is, under federal law, a requirement, and I'm going to skip this one. It's in the materials under the IDEA Act, that the state must establish a process to allow parents to deal with IEPs. And that was done in Washington. It is WAC 392-172A. And I think I've got an extra digit in there. It's in the slide, 05135, number 5. I don't know if the zero is extra, if I put an extra 5 in there. But it basically says students over the age of 18 who have not been determined incapacitated under 11130 may be certified as unable to provide informed consent. The problem with this is it requires 2 doctors' sign-offs, and it must be renewed yearly. So it's an option. It's just not the most workable option for a lot of people. Okay, now you've got a guardian. Can they control the person's place of dwelling? It does allow them to do it, but there are specific criteria on what is required. There's a lot of push-pull under our statute over control of housing and control of social actions. I think the housing placement is a little bit wider than the social aspect. If you're doing a guardian to try to keep somebody from talking with somebody, I think you're going to have a problem. And I think that's the right choice because we have the protection order statute. You can always bring a protection order. But you cannot, absolutely cannot, use it as a way to keep them from associating with people unless it's in the court order. And that's going to require some specific findings. There are a lot of misconceptions under the law. A lot of lay people have some really interesting ideas of what it cannot do. It cannot force your kids to get off drugs. I once had a client who said she was bringing a guardianship against her sister so she could get her to stop smoking because she shouldn't be smoking. Not appropriate under a guardianship. There were other reasons there. as I said, there's a lot of statutory language on how you can restrict contact with individuals. It's 11-130-335. Read that and be aware of that when you're advising people of how and what you can do. I think protection orders are a better way to do that. A new one I learned this week, or maybe last week, is I had an attorney argue that we can do things in a guardianship before we've determined if a guardianship is even necessary. So they brought an order or brought a motion to sell property under a guardianship when no guardian had been appointed. And I'm like, that's just absolutely the wrong statute. It should be brought under the power of attorney statute, maybe, or TEDRA. And I do see, and I'm always confused about this, that a lot of practitioners still don't understand a lot of your trust and estate stuff needs to be brought under TEDRA, that there's very few causes of action in an estate you can bring. And that's similar. I think even the power of attorney statute requires to bring it as a TEDRA. And I've been involved in a few of those that I'm like, what are these people arguing? So always keep in mind what cause of action exists in this. And this goes back to Ms. Jones' comment either, is we've got these nice definitions of capacity, but they technically only apply to 11-130. I think they're argumentative for other things, but they're not, they only apply to this statute. You cannot say, this person meets the requirements of 11-130 in another action and magically we can take away all their rights. It's got to be done under 11-130. The big one that is very interesting is the antipsychotic medicine. That requires a specific court order. I have been both a guardian ad litem in these cases where somebody was on antipsychotics. And why I find this one really interesting is antipsychotics aren't always what I think they are. This is somebody who was given it, I think it was like for seizures. They were given this small dose of antipsychotic medication, and they've been doing it under the whole time of the guardianship. And what the petitioning attorney said to me is, we just didn't realize this was an antipsychotic. And then we saw it was, and we kind of flipped out because they've been getting this. And actually, they'd been trailing it off big time. Like at one point, they were taking a lot more, and now they're like one pill a day or one pill a week. I forgot what it was. But that is something that needs to be approved. And of course, we do have the people who are taking antipsychotic medication. That always needs to be provided for in an order. One of the other practice tips is there are standard pattern forms out there. You can get them off Washington courts. I tell everybody, if you are a practitioner, be very thoughtful about what you put in your order. There are cases out there, one of them was under 1188, that says you should have specific findings of why a guardianship is appropriate and why lesser restrictive matters don't work, and that the pattern forms were not enough. My assumption is that was a contested case, and that's how it got litigated. I have been wondering if something under 1188 is still good law in 11-130. I saw another case where it was talking, this case was different. It was talking about who's the right person to be the guardian. And it said the same thing. There should be specific findings in the order. So anytime you're doing something goofy, I think it is worthwhile adding language to that order. There are a lot of other things that aren't in the order that probably should be, talking to different agencies and all that good stuff. So if you've got somebody on DSHS, our orders are way longer than the standard ones. And I think it is important to think about what are you trying to accomplish. So if you have something where there are, say, two children doing competing petitions, but one child has criminal issues and can't serve, I would absolutely put that in my order. If you have one of these guardianships that you wonder if it's going to get litigated, or there's concern with family, or somebody's going to try to blow this up, take some findings out of the visitor report and specifically put in what the visitors said. One of our visitors, who's local, but he does visitor work all over town, does a good job of pulling things out, putting them in his visitor report. I think some of that in your order is a good idea. Okay, so that's kind of the basics of guardianship. I'm going to jump ahead here and see, before we get to, let's talk a little bit about, let's talk, how does this happen? You start a guardianship with a petition. It is generally, when I petition, if we have a situation where there is money, I will petition for full guardianship, full conservatorship, if we think that's an option. As the investigation happens, we will sometimes move that to a more limited situation. There is a list of rights you're asking to revoke. That's one I do look at a little bit closely. I struggle with revoking somebody's right to vote unless they are so severely incapacitated that they can't speak or can't, even communicate decisions. Even then, maybe they have opinions. I don't like that one. That also does require a specific finding in the order under the statute. I see orders that it doesn't always have that in there. The other one is the right to marry or divorce. I'm very leery of revoking that right again, unless that person has issues. And again, that is required to have specific findings. One of the other one that's really interesting to me is the right to drive. And I have had guardianships where, and I'm going to open this up to the room and anybody can give their opinion. We do not revoke their right to drive because their issue is, I don't mind a guardianship, but I want to maintain my right to drive. Well, you don't have a license and you haven't driven in 20 years. And I kind of feel that's a no harm, no foul. Who cares? Put in the order. They could have a right to drive if the state will give it to them. If the state's not going to give it to them, not a problem. So I'm always very leery of what's going on. One of the problems I see with my disabled individuals is we're often not doing conservatorships because they don't have any money. And again, we don't want to be proactive. I have lots of people coming to me saying, well, they might work someday. I'm like, well, we'll deal with it someday. But I have the individual who is kind of going out about and signing contracts, and maybe we want to take away their right to contract. And and practitioners all over, we're all kind of have different opinions on what's allowed. So, okay, I'm going to let Amy interrupt me and I'll get back to that.
Okay, question. Once a guardianship for a minor is ordered by agreement of the non-resident parent, is there a way to add in conservatorship if that is found needed?
So I'm going to say we are not talking about minor guardianships at all. I know zero about minor guardianships. I have done minor conservatorships, but yeah, I know nothing about minor guardianship. It's kind of a different system. We're talking about guardianship for 18 plus. So sorry, I have no clue. There are a couple issues that I find funny about guardianship. And one of them, I kind of blew through a couple slides, is what makes a guardianship or conservatorship limited? And I think as many practitioners in a room will have different opinions. I also wonder are the revocation of rights independent from what's granted to the guardian? So I actually think I can revoke a right to contract for an individual without a conservatorship. I know other attorneys who I think are great, know this area of law, I respect very much, who argue with me, no, once you revoke somebody's right to contract, we now need a conservatorship. So that's an interesting question. I also don't really know what makes it full and what makes it limited. Again, full's easy. It's just you've lost all your rights and we've given all the rights to the guardian. I tend to take the position that what determines if it's full or limited is what rights we're giving to the guardian, not what rights we're taking away from the individual. Again, people disagree with me. So I think that's something you have to come to your own conclusion. The statute absolutely would prefer everybody to have a limited guardianship. And that's another place I would put findings in my order. If we're doing a full, why is a limited guardianship or conservatorship not sufficient? I think the statutory or the pattern form language just says, a limited cannot meet their needs, but maybe why that is. What are we doing here? Okay, so we've talked a lot about guardianship. And as I said, guardianship is a last chance resort kind of situation. We don't want to make it our first tool we pull out. So depending on who we're talking about is what are all our alternatives? Well, in Jim's ideal world, everybody would do powers of attorney to appoint somebody to make decisions for them. Because, we think guardianships are disabled 18-year-olds or our elderly person, any of one of us could get run down in a crosswalk and be incapacitated tomorrow. Anybody could be in a car accident. So life could change overnight. And I've noticed in both my estates and my estate planning The biggest messes are always younger people who have some traumatic event or somebody who dies or becomes disabled. And now it's a mess because they didn't plan. Related to this, and this is just for fun, I once had somebody call me up and said, I'm 92 years old. Should I start thinking about doing my estate planning? And I'm thinking, 92, you should have started thinking about it 60 years ago. I think we need to do a better job of convincing people this stuff is important and we need to do it. I also think we need to be thoughtful about our powers of attorney, what we're giving them and what we can do. So that is the number one way to avoid a guardianship, is have your powers of attorney in place. I think this is something that anybody with kids should be doing. There's other reasons I think they should do their estate planning that way, and we'll get to one of them later. Anybody with disabled individuals, basically any human who's over 18 should be doing some sort of power of attorney for healthcare and power of attorney for finance, or a combined one, so that they have people who are making their decisions. I view guardianship, as I said, as the last chance, is the individual who has nobody, or the individual that doesn't have family involved, because the simpler and easier way of doing this is name your child or your children or whoever is your power of attorney. And to jump that question, what do I think about joint powers of attorney? I don't love it. I don't love putting two people on there for the same reasons I said before, but it's legal. You can do it. I've had clients who want all three kids on there, and I'm just like, this is going to be such a nightmare for finances. For healthcare, it might be okay. And I try to push back, but ultimately client's in charge. Number two is limited guardianship, which is, okay, we need some help with something, but we don't need the help with everything. So we're not going to revoke all your rights. The other one that we'll talk about a little bit different is maybe we do a supported decision-making agreement, because I think there are some people out there, and I might jokingly put myself in this list, of they can understand basic things, but once you get to more complicated things, they struggle. Or I see a lot of children with disabilities who don't want to make decisions. My daughter would be an example of that. Trying to figure out where we're going for food can sometimes be frustrating because she wants to know all the choices and then doesn't want to make a decision. And sometimes we'll say, you pick, and then gives me flack if I don't pick what she wanted. So sometimes it is very hard to get people to make decisions. And I think that's a lot of reason people don't do their estate planning, is that they think, oh, I'm never going to die. I once had a client told me that when we were signing our will, which was very wild. I'm like, why are we doing this then if you're living forever? Or they're struggling with who to appoint, or they are struggling. It's just the ostrich, stick my head in the sand, nothing can go wrong. We've somebody unmuted. Question? Okay, maybe not. All right. Other options are supported decision-making agreements, which we'll talk about, which is interesting in a guardianship context. I think they need to be done together with a power of attorney. I'm not sure a supported decision-making agreement of its own is good enough, but I think combined with a power of attorney can be very useful. I work with Pierce County coalitions on disabilities, and what they're doing, because they can't practice the law, they do powers of attorney for people. They're doing a supported decision-making agreement to try to deal with IEPs that clients can bring in and sign. So that's an option maybe there instead of jumping through that thing. The big one is do nothing, is just go on with life. And for a lot of people, that can happen. I have elderly clients who end up in a facility and the kids are just handling things. You will notice one of the ones I didn't put on this list, which is the bane of my estate planning existence, which is just throw one of the kids on as a joint survivorship on the account. That is a very bad choice for a lot of people. It drives me up a wall that people don't understand that your will doesn't supersede everything unless it's a super will, and I haven't seen one of those, I think, yet. That your beneficiary designations matter, and don't just leave things to your eldest because they're the one who's going to help you out, and leave, it's one thing if you leave them a bank account with $5,000 in it, but don't do it when it's, $400,000 and they're just going to split it, because as we all know, the person named on that designation can say, legally it's mine, see ya, I'm not splitting it with anybody. So if you have a jerk as a sibling, that can be a huge problem. As I said, there's that healthcare, the 77065 healthcare consent statute, which can be helpful for medical decisions. And where I think you see a big alternative to guardianship is between spouses. Is I don't very often have issues where spouses can't conduct business on behalf of the other one. Where I see it a problem is real estate transactions and sometimes 401ks, IRAs, things like that, because it's hard to change beneficiaries. The selling point I tell everybody for powers of attorney for spouses is I had somebody call me panicked because they were planning to sell a piece of property on Friday. The person had a stroke Wednesday, and they're like, oh, he can't sign anymore. How do I sell this property? I'm like, well, did you do a power of attorney? I'm like, no, can you do one for me now? I'm like, not if they're incapacitated. Why didn't you do this way, way, way back when, so that you had your documents and ducks all in a row to be able to deal with this? So getting people to do their estate planning is so important. Like if we've got a power of attorney that is operating appropriately, there's no reason ever to need a guardianship. Now, that's not to say we have the other problem with powers of attorney, which is, and let me go to that slide, I've been yammering on. When we have somebody who is in the middle of a family dispute and the three kids all hate each other and they're all going to different places and sign a new power of attorneys every 5 minutes, we may need a new guardianship there because we may have some bad actors floating around that are causing problems. But I have seen that happen where a valid power of attorney is being operated on and the ne'er-do-well child comes in and, you know, makes mom sign one. Mom has no clue what she signed. And now we've got a power of attorney crisis. So that's why I said it usually avoids the need for guardianship. The nice thing about a power of attorney versus a guardianship is the trade-off is guardianship, we revoke rights, power of attorney, you maintain all your rights. So that's the other place that this could become a problem, is you are kind of screwing up your own situation. So what I see sometimes, I'm trying to think of a specific case, but you've got somebody who's got a power of attorney, they're doing everything fine, but this individual is going to the bank and pulling out, $20,000 and giving it to, the guy down the street every week. You might need to go to guardianship just to revoke those rights because the individual is screwing things up themselves. The other, and people can debate me with this one, I don't think you can use a power of attorney to change a will. I question if you can even do it to change a trust. But it is an opportunity out there. As I said, I practiced in a different state, and we had a little bit better statute on this topic. And even then, people would disagree with me when the statute was pretty clear if you could do that. I don't think a power of attorney can create a trust either, but people argue with me and say you can if it's granted in the document. The issue I have with that is, does that meet some of the requirements under the statute? As I said, with the disability person, I have done powers of attorney for people that a lot of people don't think probably can do them. Just because you're disabled doesn't mean you don't have legal capacity. It just may mean we need to simplify things a whole lot. And one of the things that I have done with people is picture communication. I always love it when the parent is a bald guy, because then I can put like Vin Diesel or The Rock in the thing and say, who's your dad? I am terrified someday somebody's going to pick The Rock, and I don't know how we're going to make him be the power of attorney. But picture communication. I once met with a client who was nonverbal, but when I asked the question, who do you want to make your decisions at the doctor, immediately pointed to his sister. So there are people out there who have higher level of understanding who might be able to execute documents. I've also seen it with elders. I've got a couple cases that I sometimes am intrigued about what other attorneys are doing. Got a case now where I'm one of the other attorneys here in the firm is doing, and I'm just kind of watching along, where there's a VAPO, and the argument is the person had capacity until they had a stroke, but after they had the stroke, they did a power of attorney. Now, I'm not going to ever second judge the attorney. I'm assuming they had capacity understood, but that's a really interesting question, how that got signed. I also think there's a lot of people who, if you get paid, will just sign whatever. All right, Amy, this is a good time to stop. So ask me away.
Okay. Can there be both a POA and a guardianship, maybe two people, as in mom or dad?
In theory, you can. Most of the time, the power of attorney is revoked by the guardianship. And I would argue if you have a power of attorney, how do you meet that three-prong test? Because you've got that lesser restrictive alternative. Now, what I have seen, and you can flip this either way, is let's say somebody did a financial power of attorney and there's no need for a conservatorship, but never did a healthcare power of attorney. So you could have a power of attorney still operating out there for one of the prongs while requiring it for the other prong. But no, I have never seen, thinking here, I've never seen a case where we keep the power of attorney in place because that's just that lesser restrictive alternative. So what would happen there, and I didn't mention this, and I should probably go back, when the visitor meets with the individual, one of the things they should be doing is evaluating, is there a lesser restrictive alternative we can pick? And what I have done is I've said, okay, you filed this guardianship. I don't think it was improperly brought because you kind of did your due diligence. You're a lay person, but I think this person can do a power of attorney. So we're going to dismiss the power of attorney or dismiss the guardianship once we have done the power of attorney. So that does happen in some cases as part of the process. So instead of doing the full, we execute some new powers of attorney, and those are now going to control. And basically the same thing's going to happen. And for somebody who is, I don't know what the best word is, somebody who is less responsive, that might be the best tool, is they can use the power of attorney because they're not going to screw things up. If they're a little bit more highly functional, that could be a problem. Okay, so this is where, so let's go back. Picture communication to do a power of attorney, pointing to do a power of attorney. I have power of attorneys I've done that are very simple. When I have a disabled individual, I will hog out portions of my power of attorney. Like the simple one is a lot of my powers of attorney for a competent individual who might have to need Medicaid planning allow some gifting language in them. I often take that out of a power of attorney for a disabled individual or somebody who has lesser capacity because I don't know if they're going to understand that. As I said, and this is the most important thing, and I hear this from lay people all the time, well, mom has a dementia diagnosis, she can't do a power of attorney. Well, it depends. Maybe she can, maybe she can't. I don't know. I would have to talk to her and see, does she meet the requirements? And there's a good online, and I wish I'd put it in the materials, there is a good online book from the ABA that lays out a lot of that stuff. And if anybody wants it, it's actually on my Mac computer. When I joined firms, they took away my Mac, and it's been the bane of my existence. So I had to learn a PC. But I have that, and I can send you the link. So shoot me an email if that's something you want to see. But it has some good tools and some things to deal with. Is this person, do they have capacity or do they not? But a dementia diagnosis is not enough to say they cannot do it. Alzheimer's is not enough. Autism is not enough. It just depends. And as we know from wills and as we know from legal capacity, you might have testamentary capacity today, but you might not have it tomorrow, or you might have it at 5 o'clock at night, but you don't have it at 6 a.m. or vice versa. There have been many times I have gone to sign estate planning that I talk to the individual and fine, they can express what they need, go back and see them at a different time. And it's like, I can't do this today. And I've had times where I've had to bring them in a couple times to do it because they're just not competent. And I've had cases where we had to abandon it. And I've had cases, I once had a case, this one was unbelievable, was an individual, it was all med-based. So the first time I met with them, no question they were competent. Second time I met with them, I don't think they even knew their name. And then met with them 6 months later, and it turned out it was all the meds they were being given for whatever issues they were having and dehydration and all this stuff. So it's not a one and done. Generally, for a lot of disabilities, especially for the elderly, they are progressively worse. And younger people aren't always progressively worse. I've blown up a lot of guardianships in the past 4 years since we've had 11-130 for people who I don't know if they needed this when they started or not, but are doing a lot better today. And I think that's what I see a lot with the delayed development individuals is, so at 18, they have, mental acuity of a 12-year-old, but maybe by 35, they have mental acuity of an 18-year-old. And I've seen that happen too, that they're just a little slow in getting to where they need to be, and that's absolutely fine. As I said, they need to have sufficient capacity to understand what they're doing. I really dumb it down. Who do you want to make decisions at the doctor, or do you want help with that? Do you want help with your money? And try to keep it really simple. And I've got a lot of people I've done powers of attorney for. And on the converse, I've had people that we tried. I remember going to see a young man that his mom thought he might be able to do this, and he would not engage at all. And I'm like, can't do this. We got to go look at a guardianship. In that case, we didn't need a conservatorship. And I should talk about that too. The other thing that I don't always do is parents always want guardianship and conservatorship. One of the lesser restrictive alternatives to conservatorship is representative payee. So if you have somebody that literally their only income is Social Security, you can get a rep payee in and you don't need a conservatorship. I think we have a few too many conservatorships floating around for individuals that don't need them because they really have no income and people are doing it just in case. I am trying to get rid of those for all my disabled individuals who are not working or are not bringing in any money. Those are, why are we doing this? And the big reason I don't want to do it is I'm lazy and I don't want to do that conservatorship report where we got to manage all the money. And, my dread is the client shows up with the shopping bag of receipts and doesn't have bank statements. But, okay, it's not my dread. It's more my paralegal dread, but she makes it hard for me. So there is a cost of doing that. It can be a substantial cost. If you've got the power of attorney in place, yeah, they should keep track and be able to provide an accounting. But unless somebody brings an action, they don't have to. Supported decision-making is an interesting supplement. I don't really like it alone. I have never seen a situation where that alone works, but I think it is a useful tool in combination with the power of attorney. So I once had somebody who was pretty high functioning, and this individual needed help mostly with healthcare decisions. I think they got easily overwhelmed. So what we did is we appointed a healthcare power of attorney, but we also laid out what that person will help with and what the process is going to be and what rights the individual has and what rights the power of attorney has to come help them. I've also seen people do like a board who they can go to and kind of get some help. So I'm going to talk to my sister and my brother, and then we're going to make the decision together. So I like that. I think the supported decision-making agreements are best for high-functioning individuals. I guess you could try to do it if they're suspicious of the power of attorney. I've never tried to do that. One of the things I do notice in this area of law is that people tend to be a little paranoid, sometimes under disability. That can be the case, and maybe they're not willing to sign the power of attorney. I've had a few guardianships where we end up in guardianship because, well, we could do one. They won't do it. They just won't sign it. I had a client now deceased that this was an ongoing problem because husband was taken care of because he did a power of attorney and his wife refused. She's like, I'm not giving anybody, even her spouse of 50 years, the power. I'm not signing any legal document, I think is what she did. So husband finally threw up his hands, went to get his own stuff. And when he became incapacitated, that was pretty easy to deal with. But with his wife, we couldn't sell the house to provide for the care. It's interesting how people work. And kind of an aside, if you look at gender roles, I would assume that would be flipped, that it was the guy who refused to sign. But in this case, it was the wife. She just wouldn't sign any documents. She didn't believe in legal documents, I think is what happened. As I said before, we don't use limited guardianship enough. It is favored in public policy, and you can tailor the guardianship any way you want. And I don't know if I have a slide with this, but one of the nice things about this area of law is it allows for a lot of creativity. You get to do different things. It's not just cookie cutter, put somebody in a guardianship. You can look at these things. As I said before, right to vote and right to marry must be addressed. I think you are always better off putting in reasoning for your decisions. You've got to look at the social aspects. Like I have a lot of people, I guess you can revoke it, but it's very rare. And I have a lot of people who don't want that. The guardian wants that, but the individual does not want that. And when we have a respondent attorney involved, and when I've been the respondent attorney, that's what we're arguing is we're willing to consent to a limited guardianship, but we are not willing to consent to a full guardianship, or we want to, possess our license to drive, or we want to be able to make decisions. And I didn't really talk about this, but I guess we'll do it now, is this is a fiduciary position. So you are not substituting your own judgment, and that's in 11130. You don't get to tell this person how to live. And as I said before, I've had a couple where I think we're just fighting out, long issues since everybody was 16, and they're fighting it out now. And they want to control people's behavior, and there's limits on what control. You can't make them to convert to a certain religion or give up religion. You can't, make them stop smoking. You probably can't get them off drugs. These are things they're going to do. You can't keep them from talking to, their friend down the street. I also, on that topic, and this is where things and what we do get a little bit squirrely, is where do you draw the line on what a court or what APS may consider financial abuse? And somebody may say, no, I'm okay with that. Because if I decide to give all my money away, even if it's irresponsible and maybe not the best decision, don't I have some agency in that? So, you've got the person who's given money to a child who let's just use an example, the ne'er-do-well child, but they're supporting him and they're choosing to do that. That could look really bad, but that might be their choice. But I have a hard time of how do we draw the line? And if they can't pay for their care, that's a pretty easy line to draw. Or you have the single person who's giving money to somebody of the opposite sex or same sex that the family doesn't like, but that alone might not be improper. It might be, it might not. And I think we need to look at all these questions as we're looking at a guardianship situation. As I said, there are some other things that you can revoke these rights. I don't know if that makes it limited. I think it's more what powers we grant to the guardian, but you can revoke somebody's right to make a will, enter into a contract, appoint somebody, sue or be sued. That's been an interesting one too, because I've had some people who get sued even when they're under guardianship, and I'm like, that shouldn't happen. I think there's less need for a conservatorship under the new law. I think that the guardians do have, this is what's confusing. There's some, it's not a court case, so it's not dicta, but there's some language in 11130 that seems to infer the guardian can manage money, but it's just kind of spaced throughout. And it doesn't really lay out what their powers are. So maybe the court can put in an order that if all you've got is a $5,000 bank account, the guardian can access that $5,000 account and use it to pay for care and then be rep payee. So I think there's a lot of different pieces moving around here that you can play with. And some of the vagueness is good and some of the vagueness is confusing. As I said, another alternative, and an alternative I wish people would do, is special needs trusts. And as I talked about last time, and this is a little bit repetitive for the people who were here, a special needs trust is not a thing, it's a group of things. And one of the problems that I see that sometimes can require a conservatorship is mom and dad do a will and they leave money to their disabled individual. And this disabled individual cannot manage that money. Well, the solution there is they should have done what's called a third-party special needs trust, put it in trust for the individual with somebody else managing it. So one of the big tools for anybody who has disabled children, or maybe arguably children they don't trust managing their money, is do a testamentary trust or a freestanding trust that gives the trustee the power to do that money. I've also seen some arguments, not so much in Washington, but in the state I used to practice in before, that maybe a revocable living trust is an alternative to guardianship because it's got a trustee who can manage money. So if mom sets up her revocable trust, funds it appropriately, which is the big asterisk, and then becomes incapacitated, the second trustee under the trust can trigger whatever incapacity provision is in the trust. And I'll give you a tip with that in a second, and manage the money in the trust. Now that assumes nothing is out there, but I do think trusts can be a useful tool here if they're properly funded. And I tell everybody, and when I do this presentation to individuals with disabled children, do a special needs trust. Like if you do not have a will with at least a special needs trust, or as I mentioned last time, put a special needs savings clause in your will, you can run into some big problems. Repeating what I said last time, the absolute, I think, from an estate planning standpoint, worst choice is, well, I'm cutting up a disabled kid and I'm just going to leave it all to my other kid and he'll take care of it. And I'm like, that is so playing with fire. He may do everything you want to do, but he has no legal responsibility to do that. So I think as a bar, we need to do a better job of quizzing people about that. That used to be really common when I started practicing in the 90s, as I see people come in, I'm just cutting out my disabled child. And I'm like, you might leave this child with nothing. So with the special needs trust, there's two kinds. There's the third party one that I've been talking about, and that is one created in a will. That is when it is not the money of the individual. And if you do have an individual who was competent and then had that traumatic brain injury in the car crash, you can do what's called a D4A or a D4C, a statutory special needs trust or a pooled trust, and put their money aside for them. And you've got it out of their name. It's now in a trust. The problem with trusts are they are complex and a lot of attorneys aren't going to do them. And again, I'm repeating, what do you do if we have a small amount? Well, there's this new cool thing out there. And let me look at my time here so I don't run over. We've got an ABLE account. So if you do have somebody who grandpa makes the big mistake and leaves $15,000 as a gift, and now you're going to lose benefits, maybe you have the ability to put it into an ABLE account. And that money can be moved over. They don't lose their Social Security and Medicaid. And we then have an alternative to guardianship. So there's a lot of different tools to use here so we don't go into guardianship. I remember pre-ABLE, we were doing guardianships for that kind of stuff. I was just in King County today arguing about a terribly poorly drafted trust that the court was somewhat unwilling to give the trustee a little bit more discretion in the trust, but we've got a minor beneficiary out of state. And they kept saying, well, you can do a minor conservatorship. And I'm like, great. Although we're not doing it in Washington because they live in California. So how are we going to protect the rights of the beneficiary if we're just ending the trust today and sticking them with a piece of property that is being broken into and everybody has decided it's their crack den at this point? The last one I already talked about that is really, really helpful to avoid a conservatorship is your representative payee. So there is a process. You can file some forms with the Social Security, I almost said IRS there, Social Security agency that allows an individual to be the representative payee and have the Social Security money coming in. It's in an account, and then they pay it out to the individual. So if you have a disabled individual who all they're getting is Social Security, to me, a representative payee is a great lesser restrictive alternative to conservatorship. And that's if it's a minor turning 18, if it's an adult who is living in a facility. One of the other weird things that's existing right now, that I hope this gets fixed, but when you're looking outside the family and you've got a certified professional guardian serving, it puts you in a really difficult situation because that certified professional guardian conservator needs to get paid. But right now, today, there's no real way, unless the individual has funds, to get any money from Medicaid or Social Security to pay the sort of CPGC. And if they're a conservator only, my understanding is still to this day, there is no way to pay the certified professional conservator. There needs to be a guardianship and conservatorship to do that. So that could be another wild card, is if you've got somebody who just has a conservator, how's that poor CPGC going to get paid out of the money? So keep that in mind as well. And I have absolutely seen situations where lesser restrictive alternatives were an option, but there's just nobody out there in the world who's willing to be power of attorney for this individual. And while there are professionals who would do it to get paid, they're not going to do it for free. And I would really hope that Washington considers changing that at some point in the future, that if the guardian, they're allotted a couple $100, I think, that extends to conservators and to people acting under a power of attorney if they're if they're a professional. We've talked about 77065. I think that is a very powerful tool to try to avoid a guardianship for somebody if you can get it to work. As I said, when I first started doing this stuff in the 90s, it was always facilities that were the problem or doctors. And now it's starting to become insurance companies. And I'm seeing that sometimes where we can't even make a claim and we're forced to do some sort of guardianship or conservatorship just to get somebody who will talk to the parties. So last couple things I've got in here is I've just got my conclusion, which I will talk about. I guess I've got a blank slide at the end. I do think, and I'm going to turn this off. I guess I'll just close my screen. I have no idea how to stop screen sharing once you started. I guess I do that. I don't know how to do that. Anyway, all right, I'll just close this and it should go away. I think that there are a lot of disabled individuals of all types that spend their life without needing a guardian and conservator. See, the paralegals are the saviors. They tell us how to do this stuff. There are a lot of people who can live their lives without one, and there are a lot of alternatives. Our statute has been set up to avoid them. I think our number one goal as practitioners should be to look at other tools before we go down the guardianship and conservatorship route. But there are cases where that is the only option. So I'm at 126. That leaves a little time for questions. So Amy, tell me you got 4 minutes of questions.
I do not have 4 minutes of questions. I'm just going to tell you, you have 4 minutes left.
That's no good.
That's all.
Right. So anybody, any input, anything else anybody wants to say or talk about or?
Yes. I've unmuted everybody, so please feel free to pop in. Jim, oh, I'm so sorry. I'm just checking.
All right. Teresa's got her hand up. So go ahead, please.
I was just curious, where can I start this process at for, just either the guardianship or the POA? Where do I start this process at?
Okay. Are you an attorney or are you a pro se member or kind of what, or pro se family member or what's kind of, what are you asking as far as learning?
I'm her mother. I'm her auntie.
Okay.
But her mother, I help her mother out a lot. She's actually with me. So we were just trying to figure it out. She turned 18. She has doctor appointments left and right. She's disabled.
And okay, then what I would say is call Pierce County Coalitions of Disabilities. PC2 is their website, and talk to them. They can help you with the power of attorney. You can certainly hire an attorney who knows this stuff, but we're going to charge you lots of money to do that. If you are in a situation that you are looking to do the guardianship or conservatorship, those forms, the standard forms, are all on Washington courts. And some people can do them. Some people get in trouble. What I did not talk about today is there are substantial amounts of notice requirements, follow-up paperwork. Like, this is a very paperwork-intensive thing. I have had individuals who are family members who can handle it. I have had people who get themselves in so much trouble doing it because they just don't understand. And then, as we learned in law school, so I'll pass it along to you, ignorance of the law is not an excuse. So you can't really go into the court and say, well, I didn't know I had to file this plan and this report, and I didn't know I need to serve the individual. It does not make those requirements go away. So I get, every time I do this for family members or individuals, they always ask me, should I hire an attorney? And I said, you're asking an attorney if you should hire an attorney. There's some self-dealing there. But I do generally think with a guardianship and conservative thing, I think for a lot of people, they do need legal counsel. I've seen people do it. I've seen people flail like crazy with it. So I think it just depends on your circumstances. But I talk to PC2 and get them to evaluate, see if the disabled individual can do powers of attorney. There are powers of attorney online, and I'm blanking. Washington Law Help has one, I think. I want to say maybe the Northwest Justice Project has them. I don't love them. They're not ideal, but it's better than nothing. So I guess we're 1:30, and that's a great way to wrap up unless anybody has any other questions.
No more questions, but I was going to say that there is really decent power of attorney information on Washington Law Help. It's for
do you guys have
medical.
packets that you sell or give out on powers of attorney? Okay.
No, we actually send everyone to Washington Law Help.
Okay, yeah. And I don't love it. It's not my favorite power of attorney. I like mine better. I like the one my partner uses better, but it's better than nothing. And having that is way better than just sticking your head in the sand and being an ostrich. I think ostriches are the ones that stick their head in the sand. All right.
That was that myth that we busted.
Oh, did we?
I think we did. Yes. But now I'm going to have to go look it up.
Yeah, okay. I'm going to have to. I don't know. I don't know if that's true or something I got from my childhood from cartoons, because like I learned everything from cartoons.
Hold on. Wait. I'm just double checking.
Yeah, I did. There is a thank you.
There was just a thank you. All right. Thanks again, Jim. I really appreciate it.
Thank you very
much.
Have
an awesome evening or afternoon, and I will contact you in a little bit.
Okay. Take care, everybody. Okay. Thank you very much
for listening. And I will turn in your credits for you.